If it's just to identify and, pass on to the executive, should we be rejoicing, and how might it address, issues like citizenship rights, as mentioned by Professor Joy Ilo before she left us?
Thanks for that question, and thank you for having me. It's important that always when we talk about law review, that Nigerians appreciate how we approach these things in Nigeria. In fact, in Nigeria, we have devised for ourselves two categories of law development that we embrace. We are the ones who fashioned that one. It's peculiar to us. So on one level, we have constitutional development, where we are all forever trying to become founding fathers. Everybody wants to make the Constitution over and over again. Nobody says to us, there has to be an end to constitution making. The foundation is only laid once, and you build upon it, subsequently. And so because we don't do that, we don't understand how important what we are talking about now is, because this is the entire administrative complex of our country. Without it, our agencies cannot work well. Without it, all the things that go to satisfying or bringing about the Chapter 2 objectives of our Constitution will never come to pass. And so, why is this useful, or how can we look at it today? The first thing is to remember that their task is not to amend the Constitution, and their task is not to amend or to make new laws. I've heard quite a few of our panelists say some things I find disturbing. Elections have consequences, and there's a reason why we have National Assembly. And part of the reason is because of what we are hearing now. The idea that people can sit down in some hotel rooms or some halls or wherever, not elected, and sit down and review and remake the laws to bring about ideological conclusions that they would prefer. It's not what our laws envisages. And so when you look at what they are doing today, I already find difficulties, and I think perhaps I can start from there before I get back to what you asked me. The first thing is about the Law Reform Commission. I don't see how what is being done right now will pass muster legally, because I know some people are already preparing challenges to do it at the court level. Because under our laws, once the National Assembly prescribes a mode for doing a thing, if you follow any other mode of doing it, what you are doing is prima facie null and void. And at the moment, we just passed the law in 2022 for the National Law Reform Commission. Under that law, everything that has been given to this committee now has been fully and solely given to the National Law Reform Commission. You cannot take it away. Even that commission cannot by itself decide to delegate that function to any other body. The AG doesn't have the power to interfere with that. And so, except we remember that, first of all, we may just waste all these budgets, do all this work, and then somebody goes to court, it gets knocked out. Secondly, is to remember this: that law reform is not about trying to bring about an idea of society that we would prefer. The word there is reform, not deform or to invent new ideas. And in reformation, you have to go back to what happened in Europe. That's the reformation under Luther and Calvin and all of them. What were they doing? They were trying to restore, quote unquote, Christianity back to what it was under the Bible. So they screamed sola scriptura, which means you must show that everything you want us to have to live our lives by are in accordance with the scripture, identifiable in black and white. And that's what law reform really is about. And so we have at least like 3 platforms or vehicles for doing that. You have the executives, and their mode for doing that is Section 315, where they are allowed to look of the Constitution, where they are allowed to look at the provisions of the law, find out which laws predated the Constitution, make recommendations to the National Assembly, and get some of those laws, quote unquote, reformed. For instance, since last week we have been talking about what we call criminal defamation, which is embedded in a criminal code. That's the kind of provision that right now, because of the constitutional guarantee for expression or right of expression, we should have by now gotten that law out of our books. And that's the job of the president, the governors of every state, to say every Nigeria now has a constitutional right to expression. And so you cannot criminalize their speech in deference to the character or reputation of another Nigerian. What is the interest, public interest of the nation in that? We are not doing that. So that is the mode through which the executive can interfere with lawmaking. Now the judiciary also can look at laws already made, and when cases are brought before them, they can decide this law is null and void because they are inconsistent with the Constitution. And by so doing, they help to reform the law. Of course, the National Assembly, of course, by making laws, week in, week out, are doing the same thing. So what does the Law Review Committee now do? Their job is simply to bring all these things together. Bring them together. 1948, we did that. 58, we did that. 1990, we did that. 2001, it was begun and finished in 2004, and a law was made in 2007. In each of those, must have an enabling law pursuant to the committee, except to have a commission already mandated by law, in this case, our National Law Reform Commission, to do that. And so, what we are doing at the moment should have been get the gentlemen together, they come together, collect all these laws, consolidate what has not been consolidated as amendments, find what has been struck out through judicial pronouncements, and then renumber those laws, look at phraseology, and look at what quote and unquote is difficult to understand, not interpreted. More importantly, and I will stop on this point, I hear a lot about redundant laws. There is no such thing as a redundant law. There's only a law amenable to Constitution or not amenable to Constitution. So you can't say a law is redundant because you in Lagos finds it so. How about the person in Zamfara State? You may be so sophisticated in Abuja or Lagos. The person in Nasarawa, Abuja, Zamfara, that same law you think is redundant can still be useful to them. And so that's why you have to go to the National Assembly. Go there and make your point. If that is redundant, they will let you know. Thank you.